with Scottish Government's Planning and Environmental Appeals Division, or DPA. We have been jointly appointed by Scottish ministers to conduct the examination inquiry and thereafter to report to them. Would it be possible if people could mute themselves? Because I can hear a little bit of feedback, which perhaps means I'm hearing myself speaking over your speakers. So if everybody can put themselves on mute, that should help us. Okay. As I was saying, Karen Haywood and I have been jointly appointed by Scottish ministers to conduct the examination inquiry and thereafter to report to them with a recommendation on whether or not the proposed Sheirdrim renewable energy development should be approved. I'm pronouncing that Sheirdrim. I'm very happy to be corrected if I pronounce that incorrectly, and my apologies if that's the case. Now, I need to read something to you about today's meeting. I'd like to remind everyone present that this meeting will be recorded. It will be stored as part of the DPA's webcast archive and will be capable of repeated viewing. I have the discretion to terminate or suspend filming if, in my opinion, allowing filming to continue would prejudice the proceedings of the meeting. By participating in this virtual meeting, you are consenting. Sorry, I've lost my place. By participating in this virtual meeting, you are consenting to being filmed and to the use and storage of those images and sound recordings and any information pertaining to you contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. Now, further details of this can be found in the DPA's privacy policy, which can be found on the DPA part of the gov.scot website, and I will be including a link to those in the notes of this meeting when they're published. Now, what I'd like to do first is confirm that everybody we are expecting to take part in today's meeting is connected. Some of you may have more than one representative, so what I'm going to do is go around and ask each group or person or organisation in turn to introduce themselves and their parties. So if the spokesperson can introduce themselves first and then their parties and let me know who will be speaking on behalf of everybody today, that will be fantastic. So good morning to the applicant. Could you, your spokesman, please introduce your party?
Good morning, sir. My name is Colin Innes, and I'm a partner in the law firm of Shepherd Wedderburn. I appear here on behalf of the applicant, and I'm instructed by Ms. Fiona Coyle, Divisional Solicitor at Scottish Power Renewables. Thank you.
Thank you very much. And Argyll and Bute Council, please.
Good morning, sir. My name is Maurice O'Carroll. I'm a member of the Faculty of Advocates. I've been instructed by Susan Mayer of Argyll and Bute Council, who's on the call today, along with Arlie Knox, our planner.
Thank you very much. And good morning to Historic Environment Scotland, please.
Good morning, sir. My name is Douglas Milne. I'm a partner at Morton Fraser, instructed by Adele Shaw of Historic Environment Scotland. There are a number of other representatives of HES who are joining us this morning. They will just be listening in this morning.
Thank you very much for that. West Kintyre Community Council, please. I think you might be on mute.
Good morning.
We're getting a little bit of an echo. I wonder if you might be on twice. Could you? Could I just confirm that I think I heard correctly? Margaret Pratt, is that correct?
Yeah, sorry, I'm Margaret.
That's okay. Pratt. I can hear you perfectly now.
Right, we'll start again. I'm Margaret Pratt. I'm convener of West Kintyre Community Council, and I'm here representing the Community Council.
Thank you very much. Good morning to you. Good morning, and Nigel Stewart, please.
Yes, hello. I'm Nigel Stewart. I'm a resident of the village of Clachan, which has been my home for 25 years. I'm here in that capacity to speak to my objections and also those of another 20 residents of the village who've asked me to speak up for them.
Thank you very much. And Andrew Russell, please. You might be on mute, Mr. Russell. I'm just going to flick through just to see if I can see. Bear with me. I can't see or hear Mr. Russell. I think in that case we'll just we'll continue. It might be that Mr. Russell is in the process of trying to join us, so if he does, then we'll be able to introduce him at that point. Is there anybody else present who has not been introduced already? Okay, I'll take that as a no. Thank you all very much. I'm now going to explain how today's meeting will run. For all those participating, please keep your video on, but your sound to mute, except of course when you're speaking. That way we get to we get to hear only the people who need to speak at that moment. For those observing, please turn off your video and put your sound to mute. Everyone should have their screens on the gallery view, and you can find that on the, I think on the top right of your screen. There should be an option to alter the view. It might say grid or something like that in terms of layout, so that should allow you to see all of the other participants. And then there's a little arrow on the right and left hand side, so if there's more than a certain number, it allows you to move and navigate to see other people. If any parties are in the same room, please note that we will expect the relevant social distancing and other COVID-19 related measures to be observed. And if these measures are not being observed, we may be forced to suspend the meeting until they can be. Karen Haywood and I are in the same room, but we are over 3 meters apart and all other COVID protocols are in place. So the purpose of today's meeting is to discuss the procedural arrangements for an examination to consider an application under Section 36 of the Electricity Act 1989 by Scottish Power Renewables for construction and operation of a renewable energy proposal at Sheirdrim, including wind turbines, solar arrays and battery storage. We will not be hearing any views or evidence on the merits of the proposal this morning, and I'll make that very clear now. As a reminder, we're here only to discuss the procedural arrangements for the time when we do hear those pieces of information. You should all have received a copy of the agenda in advance, which sets out the matters covered today, and you just need to check, has everyone got an agenda? Okay, don't think anyone's saying they've not. Thank you all, good. So we'll cover the procedural implications of the COVID pandemic at various points in the agenda as and when necessary. However, our assumption at this point is that we will not be able to hold in-person inquiry or hearing sessions and will instead conduct those procedures virtually in the same manner as today's meeting. Now, is everyone content with the agenda and clear about the purpose of today's meeting? Okay, thank you. I also need to say as well, I am looking at you on 2 screens, so it might look like I'm looking slightly up or across. I am looking at you, it's just my camera is in a slightly different place. I also have some notes in front of me and a screen to my left, so I might be looking slightly to one side. It will be my best side that you get to see, so that was a bit of a treat for you there. And I'll be making notes at various points, so please don't be put off by any of those things. It's just part and parcel of what this is. Okay, so what I'll do is I will go through the agenda, I'll introduce each item, I'll say a few things about it, and then I will invite people in turn to come and speak about the matter that we're discussing, and that way everyone will get a chance to say what they want to say. So item 2, code of practice for handling inquiries and flexibility for proceedings. I will now outline our approach to public inquiries under the Electricity Act 1989, with apologies in advance to anyone who's heard this before. There are no statutory rules relating to the Electricity Act cases. So in this case, the inquiry will be conducted in accordance with the Code of Practice for Handling Inquiries under Section 62 and Schedule 8 of the Electricity Act 1989. A link to that document was provided in the agenda, so that hopefully has given you the opportunity to have a look at that document if you want to, but I'll be going through it just now. The Code of Practice allows for flexible procedures to be adopted and for issues to be dealt with by the most appropriate method of examination. So that could be inquiry sessions, hearing sessions, or further written submissions. I'll talk about those in a moment. On some issues, sufficient information has already been lodged and no further procedure is required. So in a moment, I'll briefly explain what is meant by those procedures for those who are not familiar with them, and we'll be referring to those procedures later on as we get through the agenda. The report that we as reporters write for Scottish ministers will take into account all of the environmental information submitted by the applicant, together with all consultation responses and all letters of representation already lodged. So the type of procedure to be followed, or the absence of any further procedure, will not be an indication of the importance of a particular issue. So for inquiry sessions, witnesses for each party will be invited to prepare evidence and prepare precognitions in advance of the inquiry, essentially a written statement of evidence to be led. The evidence will be presented in turn and will be subject to cross-examination by those holding opposing views. Usually, parties are legally or professionally represented, and lawyers will cross-examine the witnesses. It's not essential to be represented by a lawyer, so you don't have to. The reporter will also have questions for the witnesses. Finally, the witnesses may be re-examined by their own lawyer or representative. Inquiry sessions are formal proceedings and are particularly suited to topics where there is lots of technical evidence. Hearing sessions will take the form of a structured discussion between parties, which will be led by the reporters. There'll be no formal leading of evidence or cross-examination. The reporter will prepare an agenda for each hearing session based on hearing statements that will be submitted by participants in advance of the inquiry. Everyone that has informed the DPA that they wish to take part can participate in the hearing sessions. As well as presenting their own case, parties can respond to what others have said. There is no need for legal representation, although parties' lawyers can take part in discussions. Hearings are generally more informal than inquiries that I've just described, and are particularly suited for topics where there is a difference of opinion on less technical issues. Now, that doesn't mean, of course, that we won't be discussing technical issues, but there is a distinction that I've just described between inquiry and hearing sessions. Some topics may also be addressed through further written submissions. Now, these may arise through responses to specific questions from the reporter and may range from broad invitations to submit views on a topic to specific queries on detailed matters. Where we think we have enough information and don't need to ask more questions or explore those matters beyond what we have already had submitted to us, we would opt for no further procedure. So I make very clear now, and as I did earlier, that this does not mean that the matter is not important or that the other matters are more important because they have formal sessions. It simply means we don't have more questions to ask. We will cover the procedures to be used when we get to item 5 in the agenda shortly. Our objective is to conduct proceedings in a fair, transparent, and efficient manner. And part of the purpose of today's meeting is to seek your views on the procedures to be used. Now, we'll come to those matters in detail as we work our way through the agenda. Does anybody have any queries before I move on to item 3? I'm not seeing anybody waving or indicating to me, so that's fine. Okay, let's move on to item 3. Item 3, planning for a virtual inquiry or hearing session. So in line with current DPA guidance, no face-to-face procedure can take place at this time. And by those, I mean the hearing or inquiry sessions that I've just described to you. If face-to-face procedure is possible, it is still likely to require a venue that can address the necessary risk management, and local facilities in the entire area are not likely to be suitable given the numbers of people, safety requirements, and logistics involved. We will therefore proceed on the basis of virtual inquiry and hearing sessions conducted online in a very similar manner to today's meeting. It's anticipated that an inquiry or hearing programme with any detailed arrangements and guidance relating to the virtual process would be issued by reporters 3 weeks before the event. The DPA, our office, would carry out appropriate IT testing in the 2-week period ahead of the meeting date. So if participants would like this testing, then you can request that via the case officer. That's Karen Cowie, who's contacted you. And we'll talk about contact details a little bit later, but I think the vast majority of you have been in touch with her already. You would be contacted by DPA staff for a video call, and that would be used to test things. So if you want that, then they'd be very happy to do that. If you do that, please make sure that the place where you do the test and the equipment that you use for the test is the equipment and is the place where you will be when you're going to participate in the process. We have had situations before where people have chosen to move or chosen to be in a different place or have different equipment, and it hasn't worked quite as well. So the test is important, but so too is the location. During the period of restrictions for COVID-19, the Council is not required to place any of the relevant material for this case on deposit. So case documents will be published on the DPA website only, and it's those documents that members of the public and participants would refer to in the run-up to and during the virtual event. We will provide details of the correct web page on the DPA website in the note of this meeting for those who've not yet had the opportunity to find that. Any queries before we move on to item 4? Okay, thank you. Item 4, application update. The applicant has reported to us in their additional position statement that some of the other wind farms identified in its landscape and visual impact assessment work have either gained consent or have been dismissed, and that another has also been proposed. We therefore intend to ask the applicant to provide the necessary updates to reflect this, including any new visualizations and the identification of any modifications, including any changes that might arise to conclusions, so it can express to us what those are. I propose that this material should be submitted within 21 days of the note of this meeting, so that's a little over 4 weeks from today. I'm content that this would be supplementary information covered by Regulation 19.2 of the Electricity Works Environmental Impact Assessment Scotland Regulations 2017. Regulation 20 paragraph 6 makes clear that no formal press release would be needed. Copies of this would also need to be circulated to all parties that have opted in, so that's everybody here, and to all those parties who were originally served with a copy of the Environmental Impact Assessment report. This should be done by the applicant at the same time as submission takes place to DPA. So they give it to us and they give it to everybody else as well at the same time. Those parties would then have 28 days to provide any comments, should they wish to do so. Material should be made available electronic, and any plans or visualizations should also be made available to those same parties in paper form. The note of this meeting will serve as the procedure notice to formally request that update and its subsequent comments period. For those of you not familiar with what a procedure notice is, that's the fancy terminology for the formal request for that information. We will now go round and see whether everyone is content with this and see how many paper copies, if those are necessary, various parties would like to receive of any maps or visualizations, and the applicant can perhaps confirm whether they envisage visualizations being needed. If that is the case, DPA would need 2 sets. So, Mr. Innes, please.
Yes, Colin is on behalf of the applicant. In terms of the process, we've done a mini exercise in working out the logistics of producing visualizations and being able to circulate them. And suffice to say, we had anticipated that hard copy would be required, and we've worked the deadline out that it will probably take us to the 26th of July to be able to produce the material in copy. And as I say, we've been worked through that program on the basis of the agenda and tried to come up with a realistic program to make sure that we had sufficient time to also get matters to printers. So that would have the knock-on consequence of moving the response date to the updated information to Monday, or the 23rd of August.
Okay. So I'm just looking at my calendar here to work that out. Okay. Yeah. So we'll see what were there other things that you wanted to add to that before I move on and see what everybody else thinks of
Well,
that.
no,
I think.
Yes, I mean it's just if particularly hard copy, it's the difficulty with
Yes.
we do need to line up printers, and it takes a bit longer under the current circumstances than it might otherwise. So that's one of the reasons why we felt working through the deadline we got to the 26th of July was the right time to produce the material in terms of making sure that we'd had sufficient time to do that.
And presumably the electronic material will be available sooner.
Could be, but we'd also probably want to see it printed off to ensure that
to make sure it's correct.
Yes, it's a sort of double check on the material, which is usually done as well. So the visualizations will be produced and then checked to ensure that they are what is accurate. Okay,
understood. Thank you for that. I'm just looking at my calendar and for the benefit of everybody else. Although we'll get to the broad timings of all sorts of different submissions under item 9, it looks like that could still be accommodated with people still having a little bit of time in between the 23rd of August, when they will be asked to have commented by, and then the submission of statements in mid-September. So that looks like it could work. Let's see what people's views are of that. So for the council, please, Mr. O'Carroll.
Yes, I agree with your summation in regard to the timeline. I think appreciate the reasons why it would be a little bit later, and if that would then be something that would be incorporated by the time of the statements, then I have no objection to that. I don't know if you wanted to canvass from the council at this stage how many copies we would require, but
yes, please, yes, if you'd advise of that.
If I might please request 3 copies, I will require 1, as will my planning witness and my LBI witness.
3, okay. Well, what we'll do is we'll go around and see how many everybody's looking at, and we'll come back to Mr. Innes and check to make sure that that's doable. So Mr. Mill for Historic Environment Scotland, please.
Thank you, sir. And yeah, certainly if we can come on to discuss the overall timetable later, that would certainly be appreciated. But it certainly sounds as if Mr. Innes's extended deadline for responses should be capable of being accommodated. As regards paper copies, Historic Environment Scotland would like 2 hard copies of the visualisations, and they can be delivered to Historic Environment Scotland's principal office at Longmoor House.
Okay, thank you very much. West Kintyre Community Council, please. You may be on mute. Have we lost Margaret Pratt?
I did notice that at some point there was a blue circle around Ms. Pratt, and I think she did drop out, unfortunately, shortly after that happened. So I think but I did notice that she was trying to rejoin, so it did look to be.
I'll come back then. I'll move on to Mr. Stewart, and then we'll come back and hope that West Kintyre Community Council have been able to rejoin us. Mr. Stewart.
Yes, I'm here. I have no comment on the timeline question. If I could have, please, an electronic copy and a hard copy of the visualizations, that would be very much appreciated.
Thank you. And we'll just check whether Mr. Russell has been able to join us. Is Mr. Russell on the call? Okay, I'm not seeing Mr. Russell. Yeah. Okay, I'll go back and see if Margaret Pratt for West Kintyre Community Council has been able to rejoin us.
Hello.
Hello there.
Hello. Sorry, my internet dropped out, so I had to rejoin using my computer. I do apologise. No,
don't worry about it. It's understandable. At what point? I'm not sure at what point you might have dropped out. You might not know. Had we gone on to item 4 by the time you?
No.
Right. I will recap quickly. We had Mr. Innes, for the applicant, had been asked whether he would be able to make a timetable of submitting updates to the landscape and visual assessment work within 21 days of the note of this meeting, which is 4 weeks from today. Mr. Innes advised that getting paper copies of the visualizations would be a little later, the 26th of July, he estimated, which would then enable parties such as yourselves having 28 days to comment. That would put to the 23rd of August, which seems to still fit with the broader timescales. So I'll be looking to understand whether you'd be happy with that. And if there were paper copies of material, then we would be asking how many copies you would like.
Yes, that would be acceptable to us. And I would like 3 paper copies, please.
3 paper copies. So we'll just return then to Mr. Innes. You've obviously been able to hear how many copies people are asking for in the general discussion. In terms of number of copies, I take it doesn't seem, I'm just counting up the numbers myself. And I think perhaps it's reasonable for us to assume Mr. Russell hasn't been able to join us, but we can perhaps assume on his behalf that he might want at least 1 paper copy. So I think that, Mr. Innes, do you have a view on any of that?
No, that seems fine, and understand that a number of organisations will need copies, and certainly under the current rules, it's probably better that they get the copies once rather than trying to try and get them copied. Because that too can be a bit logistically difficult. So we can provide the necessary copies.
Thank you very much for that, and thank you all for your contributions there. Okay, let's move on then. We also intend to ask whether there has been any change or changes to legislation or council or government policy since the applicant's planning statement in October 2019 and the council's report in August 2020 were produced. This update can be given in response to a further information request, which we'll cover in items 5 and 6 on the agenda, so I'm content we can pick those things up then. We also note that the environmental impact assessment report dates from October 2019. Additional environmental information was published during 2020. When it submitted an additional position statement 4 weeks ago, the applicant did not envisage any further environmental information. So I need to ask again, Mr. Innes, is there anything more that you would expect to be coming our way?
Nothing apart from the cumulative matters, which we will ensure covers all cumulative matters. So whilst it'll probably focus primarily on landscape and visual, we will undertake a check to ensure that no other topic matters are engaged. And so that will be the only matter that could come forward. But at this stage, it's not anticipated, but we will make sure we consider all potential cumulative matters in that update.
And presumably in doing so, at the point when you are on the 26th of July, you would be able to advise us of that position at that stage?
Yes, so it will be a single document.
Thank you. Okay, thank you very much. Does anybody have any more queries on item 4 before we move on? No? Okay, thank you. We'll move on now then to item 5 on the agenda. Item 5 is the reporter's current thoughts on topics and issues, provisional assessment of the procedure and anticipated participants. And this relies on annexes A and B, which were attached to the appendix. Item 5 is where we consider the topics and issues that we, the reporters, think are being covered, and our provisional thoughts on what procedures to use when considering these matters. I'll say a little bit first, and then, as before, we'll go around each of the parties and see what people's views are on this. Now, I'm just going to refer to Annex A myself. So I'm just going to read through those topics just for anyone who's trying to balance 2 screens at the same time, or anything like that. So the topics that we'd identified: landscape and visual, including cumulative but excluding Dunskeg. I'm happy to be corrected on my pronunciation as well, so please do that if you feel the need to. Archaeology and cultural heritage, including Dunskeg. Socio-economic, recreation and tourism, draft planning conditions, legislative and policy context, ornithology and ecology, aviation and defence, access, traffic and transport, hydrology, hydrogeology, geology, soils including peat, forestry, air quality, noise, shallow flicker, telecommunications infrastructure including television reception, carbon balance, population, human health, risk of accidents and disasters, waste and environmental management, decommissioning and restoration, grid connection and engagement. So a big long list of things. You will recognise that some of those are quite similar to topics covered by the environmental impact assessment report, and in our view, they cover most of the things in some way, shape, or form that were covered by representations and consultation responses. I need to advise you, please do not be alarmed by the fact that draft conditions is listed. It is necessary to discuss conditions that might be applied in the event that the application receives consent. The fact that the topic and a session is being considered does not in any way prejudge whether the application will receive consent or not. It's simply something that we need to discuss. Annex A also sets out procedures that we currently think should be used for each of these topics. Now, this is not written in stone. It's very much open for discussion today. That's one of the main purposes of today's meetings. I have already explained what's meant by the terms inquiry, hearing, and further written submission, and no further procedure. And I also reiterate the point that the procedure suggested should not be taken to mean that something is or is not important, or is more or less important than something else. Now, you can see from the list in Annex A that we think we have sufficient information on the majority of topics and do not think we need to ask for further information on those. We've therefore concluded that no further procedure is necessary in those instances. For the remaining issues, we think we need to consider those matters with either further written submissions, hearings, or inquiry sessions. Now, Annex B takes those topics for which we have identified further written submissions, hearing, or inquiry sessions, just puts them on a fresh sheet of paper, and it identifies some of the parties that we thought would wish to participate or need to respond. Now, again, this is not written in stone, so it is very much open for discussion. My apologies if you wanted to be involved in that and your name wasn't on it. If your name is not down and you would like to participate, that's fine, please tell us. If your name is down next to something and you don't want it to be, that's also fine, please tell us. And we can deal with that in just a moment. I also need to mention to you that RSPB has now received correspondence from the applicant and has confirmed that its queries have been answered. However, we have not yet seen the information that they have been provided with, and so we will still need to ask for a further written submission on ornithology. So we're now going to go round all of the parties to find out whether there are any other significant topics raised in representations that you don't think are covered by the list that I read out from Annex A, to find out whether you are content with the proposed procedure for each of the issues that we've identified in Annex A, and to see whether Annex B correctly identifies the topics you wish to give evidence on. And if not, then please tell us where you think your name should be next to, and we'll put it there. So let's now go round again and we'll speak to everybody. So Mr. Innes, first of all, please.
Yes, on behalf of the applicants, we're content with the topics and means of consideration of all the matters, and believe it comprehensively has considered the relevant matters. And I take it at this point we're not discussing timing of issues, but just that broad thrust of the topics. So I have nothing further to add. Thank you.
Thank you very much. And for council, please, Mr. O'Carroll.
Thank you. I do have some comments to make. The taking A and B together, I should inform the inquiry that at this stage it is not the council's intention to lead separate archaeological evidence in relation to Danskeg. That had been initially in contemplation by the council, but is not any longer. So there will be no cultural heritage witness being led by the council.
Okay, thank you.
Having said that, what I would like to make clear is that the matter of Danskeg obviously is something that is relevant to landscape and visual impact evidence. So that will be something that will be covered in that context by the council's LVI witness. So,
do you mean in general, or are you intend to be part of the inquiry session to deal with landscape and visual evidence? And are you saying that that's where the matters that are of interest to you will be discussed?
Yes, if I could just absolutely clarify that.
Okay.
There will be no separate, under the second row of your Annex A, the council will not be participating in that.
Okay.
Under the first row, landscape and visual, The council will be participating at the inquiry. The council agrees that the inquiry is the most appropriate procedure to use. As part of the landscape and visual evidence, there will be mention made of Dunskeag as part of that overall landscape and visual assessment.
Okay.
So what is not envisaged is that we would have the same witness appear twice under those two separate categories, because that would already be covered under the first of those rows.
Okay.
If I could then move on to make another observation, I think it saves time if I just deal with it now.
Yes, that's fine.
In relation to what you have in Annex B, it is, of course, appropriate to consider matters to do with socioeconomic recreation and tourism. Again, tourism is something that would be mopped up in the round in view of visual impacts, in particular, as part of the LVI evidence that will be led. The council does not anticipate, unless the inquiry wants it to, but nothing else being said, the council would not anticipate leading a witness separately on the topic of socio-economic recreation and tourism. So we are listed there as the second anticipated party participant there. But if I could just therefore correct that, so that in fact the council shouldn't be included in the prior column at number 3, and it shouldn't be included at number 2 of Annex B of the third row of that Annex B box that you have there.
Understood. Okay.
Thank you. If you just bear with me one first.
Yes, of course. Yes, please take a moment. Yeah. I think that's the only observations I have at this particular point. Thank you. No problem. Thank you very much indeed. Mr. Mill, Historic Environment Scotland.
Thank you, sir. Historic Environment Scotland is content with the proposal that there is a standalone session which deals with the archaeological and cultural heritage issues regarding Dunskeag, and that be dealt with at an inquiry session. The only point that I would make, really, I suppose by way of response to what Mr. O'Carroll has just said, is that whilst Historic Environment Scotland will not be participating in the landscape and visual inquiry session, it may be that they will be making reference to the landscape and visual materials in the environmental impact assessment report during the archaeological matters inquiry session.
No, I understand that. That's
I would also mention, again, really for the sake of completeness, I appreciate this is a bit obvious, although Historic Environment Scotland are not intending to make any written submission on legislation and policy. They will be making reference to appropriate policy and non-statutory guidance in their evidence at the archaeological inquiry session.
Okay. No, thank you for that. Okay. West Kintyre Community Council, please. You might be on mute.
Sorry about that.
That's okay.
We're happy that we would wish to be with the landscape and visual. With regard to socio-economic recreation and tourism, we do have two issues have arisen, big tourism initiatives since the application was made. So I'm not sure whether you would prefer I just include this in our hearing statements and preconditions, or whether you would want me to do a separate piece at the hearing with regard to two new major tourism initiatives that have happened within Kintyre recently. Namely, if you want to know, they're the Sustrans long distance cycle route Campbelltown to Inverness is now operational, and the new Kintyre 66 driving route, which is the equivalent of the North 500. which has just been launched. Very important for tourism in the area.
I would certainly expect you to make reference in advance to those, and the hearing statement would seem like a good place to do that. We'll come back and check with other parties that have not had a chance to have any view on that in just a moment. But in terms of participation in any of the other matters, were there any others that you wish to participate in where your organisation's name is not down?
No, we're happy with where we're listed.
Okay, that's fine. And I take it there were no other topics or anything like that. You were content with both annexes A and B as written?
Yes, we're quite content, thank you.
Thank you very much. Mr. Stewart, please.
Yes, thank you, sir. I'm not a professional in these matters, nor of this process, so I just need some help and clarification.
Yes.
And forgive me if I stray into areas that other people just know the answers to.
No, that's all right.
For that.
The purpose of this meeting is to allow you to do these things, so
thank you so
please
much.
go ahead.
I was interested in what Mr. O'Carroll said, because my own thoughts about the question of Dunskeag, it's pronounced Dunskeag, by the way.
Thank you. No,
locally, anyway. It seems perhaps a little artificial to me to separate Dunskeag out from the landscape and visual. It seems difficult to me as a local to talk about the landscape surrounding this area without mentioning Dunskeag. The reality is that it's part of a wider historical network whose proper interpretation is crucial to a modern day understanding of the historical and cultural development of the area around the West Loch. So I don't know whether I'm entitled to speak about that under the first topic, or whether, if that's restricted to the second topic, I'll put my hand up and say, please, can I be added to the second topic?
I understand. I think what I'd be very happy to do is add you to both. I'm interested in obviously the views that you've put forward. I'm aware that landscape and visual, Mr. Milne has alluded to this, so has Mr. O'Carroll, is the basis, or is at least part and parcel of a number of topics which are identified separately. And part of the reason for doing that is to enable us to cope with them individually, accepting that, of course, matters that may find themselves under discussion might be ones that would be covered by different sessions as well. So it's not an attempt to suggest that you can only talk about landscape and visual on its own and only that on the first session, and then somehow that you wouldn't be allowed to speak about it at all in the other sessions. That's
I'd be happy if you'd add my name to the second session,
okay.
If for no other reason that there'll be nobody from this side of the West Loch there to speak to this.
So you'd be happy to be added to the Dunskeag. Have I pronounced that correct?
Please, if you don't mind.
Dunskeag, okay. And any of the others?
I have one other question, if I may.
Please go ahead. Yeah.
And this is me, as I say, speaking as not a professional in these matters. But I've read the application, the EIA, all the reports, the comments from statutory consultees, and they all refer to physical things, like the impact on the landscape.
Sorry to interrupt you, Mr. Stewart. Mr. Smith has lost.
I can hear now.
Connection.
I'm returned. I'm sorry. Can you hear me?
Yes, I can hear you. Fine.
That's fine. My apologies to everybody. I was saying I couldn't hear you, but you probably couldn't hear me saying that because for some reason I disconnected. I can now hear and be heard. So would you mind repeating that? I'm sorry.
Yes, I certainly will. The point I'm trying to make is that the application, the EIA, all the reports, the comments from statutory consultees refer to physical things like the impact on landscape or categories and qualities of different parts of land, on forestry, wildlife, ornithology and peat. And I found it hard to find a mention anywhere actually of people, and especially the people who live here. I'm just wondering under which topic will there be the opportunity to consider the physical presence of this development and its impact that local people feel it will have on their amenity in their daily lives in their village?
Yes.
Is this topic one? Is the village and the people who live here one of the receptors that's referred to?
Yeah, certainly. I mean, there are various receptors, and indeed, my understanding is that it's entirely possible some of the things that you're alluding to there might well form part of the discussion. I think it's also plausible to recognise that some of those same matters might find themselves under socioeconomic, recreation, and tourism. I suppose each of them has a slight leaning towards an academic discipline, which you can see from the title, but I certainly wouldn't expect you to not feel. Sorry, let me say that again. I wouldn't expect you to feel that you weren't able to describe some of the concerns that you've got where they relate to the matters in question. So, for example, on the landscape and visual one, if you have specific evidence that you want to lead about some of the impacts that you described, then that could plausibly sit under that, and it will be possible to pick some of those up, I would imagine, under the socio-economic, recreation and tourism heading, which I note that you're down to participate under. So it would seem that if any of those appears to be a logical one to you, where there is related evidence that you think you want to put forward, then you would certainly have the opportunity to do so under those.
Okay, under landscape and visual, or
yes, under either, under either or under both, depending on what it is. But it will be for you to decide, I suspect, which.
Yes.
I can't tell you which evidence to put under which thing. That's obviously a choice for you. But I certainly think either of those has the opportunity for that to be said. So I've got you would like to participate in the archaeology and cultural heritage session.
Yes, for the reasons that I mentioned about the wider aspects of Dunskeag in relation to the cultural development of the area. Thank you.
That's fine. Thank you. Okay. And I will check whether Mr. Russell has been able to join us. I'm not aware. I can't see Mr. Russell. So for now, I will assume that the things that we've put Mr. Russell's name next to, which happens to be all of the sessions except planning conditions, and he will have the opportunity to review the minutes of this meeting when it comes out and make his choice accordingly, if that's something he would like to do. Okay, thank you all very much for that. I'm going to move on then to item 6. The draft list of further written submissions, including draft conditions, reporters' current thoughts. This relates to Annex B as well. At the bottom of Annex B, you can see a list of matters upon which we intend to seek clarification using further written submissions. You can see that the first 4 of these are also matters listed in Annex A. We've just discussed them. I've mentioned as well the issue about clarification relating to RSPB. We will still need to ask that, even though RSPB have told us that they're content with the answer they have been given. Yeah, so you can see the list down there. So I don't intend going over them again in particular detail, but I make clear now that following further written submissions, we'll subsequently expect the submission of finalised written statements on conditions and also agreed matters alongside hearing and inquiry statements. I also make clear now that we expect the applicant and the council to begin their discussions on draft conditions, and for the applicant, the Council on Historic Environment Scotland, to begin any discussions on agreed matters without further delay if they've not already done so. We will cover a lot of these items in more detail when we get to items 9 and 11, because we'll be able to discuss some of the time frames and what have you. But I'll now invite parties to respond if they wish to. Mr. Innes, please.
Nothing to add at the moment, so just probably more about timing. But I would say we have already kicked off the process of statements of agreed matters in relation to landscape, visual, cultural heritage and planning matters, and also formulated a set of draft conditions. And certainly the anticipation through that process is to narrow as much as we can between the parties and reach as much agreement. So by the time that we submit inquiry statements or written submissions, that effectively those will really be primarily focusing on the differences and hopefully will narrow issues. And we think in terms of timetabling, it's sensible for those statements of agreed matters to sort of go in at the same time as the inquiry statement, because at that particular point in time, we will have sought over the summer to seek to narrow and resolve as many of the issues as possible. And appreciating that in this virtual world, it is all the more important that effectively the virtual time is used effectively in the sense of it is more difficult in some respects, and therefore it puts a premium on trying to get these matters in as an advanced state of agreement as we can. And that's certainly one of the lessons that we have learned from previous experience during virtual proceedings. And that's what we intend to try and achieve through that process.
Okay, good. Thank you very much. Mr. O'Connell, please.
I can confirm what Mr. Innes has just said, and I had sight of the first draft of the statements of agreed matters, and those are underway, as anticipate will be the suggested conditions as well. That's all in hand.
Okay, thank you for that. Mr. Mill?
Yes, thank you, sir. Likewise, on behalf of Historic Environment Scotland, we have now received the first draft of a statement of agreed matters relating to cultural heritage, and that's receiving attention. And it does make much sense to use the summer to agree what can be agreed with a view to inquiry statements when they are lodged, focusing on the issues which are actually in dispute.
Thank you very much. West Kintyre Community Council, please.
Okay. We're happy with everything that's been discussed so far.
Good stuff. Thank you very much. Mr. Stewart?
I have no comments on item 6.
Thank you very much. I'll check again if Mr. Russell has been able to join us. Okay, well, again, the matters that are covered by this, you will have the opportunity to see in the notes. Okay, thank you all. We'll move on to item 7. Draft inquiry procedures for considering landscape, visual and cumulative effects, and for considering the effects on the setting of Dunskeag. The reporter's current thoughts. This relies on Annex C. So item 7 is where we look in detail at the inquiry sessions that we've already talked about under item 5. The information set out in Annex A, we've listed 2 sessions. So topic 1 covering landscape and visual effects, including cumulative effects of the proposal on various receptors, and topic 2 covering the assessment of the proposal's effects on the setting of Dunskeag. I've already explained that an inquiry session is a formal process when parties are invited to present evidence and are then cross-examined by those of opposing view. You need to be prepared to present evidence and to be cross-examined on it, and also to cross-examine those of opposing view. So that will probably mean attending the full session. Sessions like this work by parties submitting inquiry statements which set out their case and identify any witnesses and list any documents they intend to rely on. And these are followed later on by precognitions, which are no more than 2,000 words, and they set out the evidence for each of the witnesses. All of the material will be submitted in advance, so there are no surprises. So we don't just turn up and say the things that we want to say. It gets expressed earlier so that everyone can see and consider what other parties have said. The applicant is usually invited to present their evidence first, as they're the ones proposing the development, and their first witness would present their evidence and then be cross-examined by the other parties, each in turn. The reporter may then ask questions. The applicant may then re-examine their witness, and then the process repeats for all of the witnesses of the applicant and then subsequently for all of the other parties who are participating. Annex C proposes the order in which participants would give evidence and cross-examine the witnesses of opposing view. we need to decide whether the participants list is correct. Now, I know we've just discussed that, so I think that will be a speedy thing to do. Whether the order of giving evidence is the correct one, how many witnesses are intended to be brought, how long evidence giving and cross-examination is expected to take. Now, I know that will be an estimate, but it all gives us a sense of how long we think we need to programme to hold that inquiry session. Now, parties may wish to group together. This is allowed and can save time and avoid repetition. At the inquiry, I will stop people if they ask questions that have already been asked. The questions only need to be asked once, because we only need to hear the answer once. I think this question has already been answered, but I will ask it to be in any case whether the Council and Historic Environment of Scotland intend to group together for topic 2. As I say, I think you've already answered that question for me, but I'll give you the chance to clarify that. And whether Mr. Russell, who is not with us, Mr. Stewart and West Kintyre Community Council intend grouping together for topics 1 and/or 2. Don't worry if you aren't sure yet or haven't thought about this yet. You are not obliged to work together, but you can if you wish, and sometimes it can share the workload and help avoid repetition. So it might be something you want to consider after this, and if you decide that you do want to work together, that's fine. You can let us know in advance of the inquiry. And if you decide you don't and you'd rather go on your own, then that's fine too. I realise we've covered participation under item 5, but it's not unusual for people to understand more clearly what this is about as the agenda progresses. I will assume, therefore, that nobody's changed their mind, but if you have all of a sudden changed your mind in the last 5 minutes, then that's fine. You can tell us about it now. The availability of parties has also now been clarified, and it appears that the Council cannot make the weeks originally suggested, but can do the weeks commencing the 22nd and the 29th of November. I understand that the applicant in Historic Environment Scotland can also make those weeks, except the Historic Environment Scotland cannot do the 19th or the 22nd of November. I'll ask you all to clarify that in a moment. DPA cannot run a session on Friday the 26th of November. So I would therefore ask you to consider Monday the 22nd, Tuesday 23rd, Wednesday 24th and Thursday 25th of November, and all of the week commencing Monday the 29th of November. So I've said quite a lot, so I'll just recap it quickly. So what we're after is an idea of witness numbers, the time for evidence and cross-examination, your availability on the dates I've talked about, whether you think the order of parties giving evidence is appropriate, and if you have any views on the order of inquiry, so should topic 1 go ahead of topic 2. We'll now, as before, just go around everybody and see what views there are. So Mr. Innes, if you would like to go first, please.
Yeah, thank you, sir. In terms of dealing with that last point first, I think there's a logic in doing the landscape and visual first, followed by the archaeology and cultural heritage. I think it makes sense. In relation to both those sessions, the applicants would have a single witness. In terms of the landscape and visual session, it's anticipated that the applicant's witness, given the number of parties participating in examination of chief, cross-examination, re-examination, may take probably slightly more than half a day, I would anticipate. And in relation to my cross-examination of the council's witness, I would anticipate that might be in the order of half a day, depending on matters, and slightly briefer with the other witnesses anticipated. In terms of the cultural heritage session, that has fewer participants and fewer parties cross-examining. I would have thought that might last, and it seems quite a focused issue, but we might well be a matter that could be probably a day or just over a day in dealing with the respective witnesses. So that looks like probably almost 4 days of public inquiry if you were leaving some leeway, but I would be hopeful that it might be more towards the 3, but it's just that our experience of the virtual world is it does take a bit longer in terms of the back and forth, and that's understandable. But that's sort of the anticipated timescale, and I do anticipate that matters will become quite focused given the time that we have and the engagement that we've already had with other parties, and that in itself saves a lot of time. So that's a broad indication of where I think it could be. And I've just got one further matter I was going to raise in relation to the inquiry sessions, and that's in Appendix C of the matters. There's a topic that the reporter's current thinking on inquiry sessions, and at the bottom of that, it's got a reference about documents and disclosure, and it talks about an inquiry report or big statement can be submitted for each topic to support the precondition. Now, I just wanted to be clear because, again, this has caused a bit of confusion with certainly other parties at previous inquiries. Our understanding is the inquiry statement is effectively the outline of the case you wish to present, together with the list of documents and your witness and qualification. But in addition, given the limit of 2,000 words and preconditions, it's fairly common now at the time of lodging of the documents for a party office to lodge something called a report as well, which is essentially an update on all the matters that might be raised under the topic, but it's usually a report prepared by the witness, and the precondition being restricted to 2,000 words is really the summary of that. And we've had issues in the past, as I say, with confusion about what's required in an inquiry statement, what an inquiry report is, and the relationship with the precondition. And I just flagged that as I think parties who are perhaps not familiar with the procedure did not appreciate that they could put something in at the document stage that was longer than 2,000 words, and then having watched all the others put them in, felt that they'd sort of missed an opportunity and felt constrained. So I just thought it was helpful perhaps just to clarify that particular aspect, to make sure that people, if they want to lodge a longer document, they can do so, but it got to be done at the document stage, and it must have been foreshadowed by essentially the inquiry statement, which sets out exactly how you propose to prepare and all the documents you propose to reference in the context of your case on those inquiry sessions.
Yeah, thank you for that, and we'll hear any views on that. Yes, I mean, certainly reading that again, I think I'd certainly want to make clear to people, yes, there will be an initial submission. I will come on to it in item 9. There'll be a submission of inquiry statements which should outline your case, and yes, those can be more than 2,000 words, and then the precondition is 2 weeks before the inquiry, and that is the very focused thing. Just a moment. Mr. Innes, I'm sorry, I'd misunderstood. Would you mind just repeating that bit again, and just so that I and everybody else, because I might have then confused people again by having misunderstood you.
Yeah. Well, in terms of documents, if in an inquiry session, the first document's the inquiry statement, and it sets out the particulars of the case and gives a summary of the evidence that you propose to lead. Will also provide the name and qualifications of your witness and all documents that you propose to lead in the context of that particular inquiry session. On top of that, at the time of lodging documents, it is possible for a further document known as a report to be lodged as a document to the inquiry session. And it is fairly standard practice that in relation to something like landscape and visual, that 2,000 words is probably an inadequate length for the witness to fully set out the particulars of the matters they may want to raise at the inquiry session. So they lodge a report as a document, and then their precondition is a summary of their position in less than 2,000 words. And what had happened in the past is that, as I say, third-party groups had understood the whole point about lodging an inquiry statement, but did not appreciate that they could lodge effectively a report as a document which sets out their case more fully, and felt that they hadn't having watched other people do that, felt that there was an opportunity and I felt constrained to the 2,000 words. So that all I was saying, that there is that opportunity at the document stage to lodge something that might be more than 2,000 words if 2,000 words doesn't meet your requirements. So as I say, that was what had happened in the past, and there'd been a bit of confusion, and it had, I think some third parties had felt that they hadn't understood the process and that they had been artificially constrained in the volume of material that they'd submitted in relation to an inquiry session.
No, thank you for clarifying that.
Yeah.
Sorry, I'd mixed myself up with something there. So yes, no, no, thank you for re-clarifying that for us. Okay, let's move on to. Sorry, I just lost my place. Yeah. Okay, Mr. O'Carroll.
Yes, thank you. So looking at Annex C again, it makes the best sense to have what is currently inquiry topic 1 where it is, and to lead landscape and visual evidence first. I'm content with the order proposed, and that's what I would have expected. To provide a little bit more detail with regard to inquiry topic 2, which I've already mentioned, as you said, in terms of earlier topics, it's not the intention of the council to formally group together with anyone else. But what I should mention, I have already mentioned how it is that matters affecting Dunskeek will be addressed by the council, will be all part of its evidence on topic 1. However, where there is other specific cultural heritage evidence led by Historic Environment Scotland, I fully anticipate that what Argyll and Bute Council will do is to adopt that evidence, and it will save duplication in doing that, and also something far short of a formal collaboration with Historic Environment Scotland, which wouldn't be appropriate anyway. So that's the extent of that. It'll be a mere adoption of that evidence. So with that said, in terms of duration, the only oral witness, well, the witnesses that the council will have would be to be a planning witness for the hearing sessions to do with conditions, and there would be an oral witness to lead evidence on landscape and visual impacts. In respect of the lengthier of those two, the LVI evidence, I anticipate that, like Mr. Innes, I think we're looking at half a day of each. So I anticipate that, based on previous experience, that my own witness will probably be cross-examined for about half a day. Equally, myself, for my own part, I would anticipate being approximately half a day, maybe slightly more. So we'll say half a full working day of 4 hours in respect of my cross-examination of the landscape and visual impact witness that is led on behalf of the applicant. So with that said, and bearing in mind the other procedures that are being envisaged by you, sir, I would agree with Mr. Innes's overall summation of the likely length of evidence that would be required would be somewhere in the region of 4 days. I think comfortably would cover it all. And in that event, then it would be concluded in that week of the 22nd of November.
Did you mean, sorry to butt in, did you mean when you said 4 days there, 3 to 4 days, did you mean just for topic 1, or did you mean both topic 1 and 2?
No, I think the whole inquiry, I think, could be concluded in 4 days.
Okay.
But in terms of my own participation, I anticipate that my witness would probably take half a day, and I would probably take half a day in cross-examination of the applicant's witness.
Okay, thank you. Okay, Mr. Mill.
Thank you very much, sir. First, in terms of the Historic Environment Scotland grouping with any other parties, Mr. Carroll has explained that the council is not intending actually to participate in session number 2. So that's clear. Historic Environment Scotland will not be grouping with any of the other parties. As regards the number of witnesses, that is still to be finalised by Historic Environment Scotland, but we may have up to 3 witnesses, perhaps 2. As regards the duration of the inquiry session, whilst it might be possible, despite the fact that I'm talking about potentially three witnesses for my clients, it might be possible to conclude the evidence in a day. But I think, and I think this does reflect what Mr. Innes said, it could trip into 2 days. So the safer way of proceeding would be to set 2 days for the cultural heritage evidence. Now, one of our witnesses, as you've already noted, sir, is not available on the 19th or the 22nd, and I was actually going to say if the 23rd could be excluded from cultural heritage evidence as well, that would be extremely helpful from our perspective, and it does sound as if that may be fitting with how things are shaping up in any case with LVIA evidence taking those 2 days. So in line with what Mr. O'Carroll has said, it could be that LVIA is on the 22nd and 23rd of November, with the cultural heritage session taking up the 24th and perhaps some part of the 25th. The last thing that I would say is to thank Mr. Innes for having raised the question regarding inquiry statements. I too had wondered if there was some scope for confusion around what's expected of parties there, and the only point that I would add, and I appreciate this will come on to timetabling, is to allow sufficient time between the lodging and intimation of inquiry statements and then the lodging of the reports by witnesses, and not to rush from one procedural step to the next with too much haste, because of course the reports need to be prepared with reference to what has been articulated in those inquiry statements. Thank you, sir.
Okay. Thank you very much. West Kintyre Community Council, please.
Thank you, Mr. Smith. Well, my experience of previous inquiries is that we haven't really required a huge amount of time, because we've tended to speak to our inquiry statement and then ask questions of the applicant if they arise and we feel there is necessary clarification. So that has normally taken place within the normal days that the applicant and the council have set aside, and your good selves, where we have however long it takes, and it's not usually taken very long because most of it is covered by the council themselves. Okay. And of course we have the odd question that we need further clarification, or indeed the reporters themselves require clarification from ourselves, or question ourselves. So I don't anticipate that we would require a huge amount of time within the inquiry, as long as we're given the opportunity to question the applicant and any witnesses.
Mm-hmm. Yes, there would be opportunities, of course, for cross-examination. That's helpful. Thank you. Okay, Stuart?
Yes, thank you, sir. My lack of experience of these matters makes it difficult for me to predict how much I might want to say, but yes. I won't be detaining you. I mean, I agree with Margaret Pratt has just said. The main focus, apart from what I might be saying, which will be fairly brief, would be on asking questions. Mrs. Pratt and I think, have already agreed that we will speak together okay. If there are issues that we can, as it were, collaborate on to assist the process, then we will do that. I don't know whether Mr. Russell would join in with that or not. Can I just clarify, we've in the last discussion at item 5, we spoke about, and I think you kindly added my name to topic 2. Yes. And I think you also confirmed that this is not although it says in Annex C, assessment of the proposal's effect on the setting of Dunskeag, it is, in my estimation, a wider issue in terms of the historical and cultural development of the area, which Dunskeag is critical to, and I think you've acknowledged that, which I appreciate. And so I think that really takes me to the point of saying I'm happy to move on.
Okay, thank you very much. And I'll invite Mr. Russell if he's been able to join us. No. Okay, well, he'll be able to see the notes of the meeting. Can I just clarify? I'm sorry, Mr. Stewart. I've just reminded myself, just looking back at my note there. You'd mentioned that you would possibly group with West Kintyre Community Council. Did I understand that correctly?
I don't know whether that's a formal.
Okay.
Sorry, it's my lack of knowledge of these technical. Okay. I know that Margaret Pratt and I have discussed getting our heads together to see how we can help facilitate the process that you have to take us all through. I'm not sure that amounts to a formal grouping between me and Margaret Pratt or Mr. Russell for that matter. All I'm trying to say is I think there are issues where we will not want to duplicate what you're listening to.
Fair enough. Yes, I understand.
If I could put it that way. But now that you've raised the point, I don't know whether Margaret Pratt was offline. I know she went offline, Charlie, was offline when you kindly added to me to topic 2, but I'm not sure whether, because I made the comment that there'd be nobody from the west side of the loch speaking about this topic, when you've kindly added me. I'm not sure whether West Kintyre Community Council wanted to be added to that.
Ms. Pratt did confirm that she was happy with what had been suggested. I'm happy to be told different by her just now if she's changed her mind.
Mr. Smith, may I just come in? It is something I had thought about but haven't discussed fully with Mr. Stewart as to whether we should collaborate on the whole session or not. Can I come back to you in due course once I've had the opportunity to speak properly with Mr. Stewart?
Oh yes,
and
certainly.
the Community Council as to whether this is the best way forward.
For sure, yes. I mean, certainly we're not expecting to put you on the spot just now and for you to decide at this moment. The idea was simply to advise you that it was a possibility, that it was something you decide you wanted to do. If you go away and decide it is, then that's fine. Please let us know. If you decide it's not, that's okay too.
I think it's an excellent idea, but I just need to discuss, obviously, with the members of the Community Council as to whether they feel this is the best way.
I understand, yes, that's perfectly reasonable, thank you. Okay, thank you all very much. Let's move on to item 8 then.
Mr. Smith, I'm sorry to interrupt you. Just before you do move on to the next topic, I think there's something I should mention now.
Okay.
I was going to mention a matter at the end of business under any other business, but I think it might have a bearing on the witnesses that the council leads, so I think it's appropriate I raise it now.
Okay.
And it's to point out the following, that in the council's resolution at committee to object to the proposed development proposed by the applicant, there was actually an amendment to that proposal to object, and the amendment specifically mentioned the particular effect on Clachan and White House villages. So it wasn't just a blanket objection on landscape and visual impact grounds, it was actually refined in the actual, as will be seen from the minutes of the council meeting, where the decision to object was made. Okay. I mentioned that then because the effects on Clachan and White House might well be incorporated again in the landscape and visual evidence that I'll be leading. But I wanted to raise it now because there might be a possibility, because I haven't actually seen even a draft version of what my witness will produce by way of a report. But there is a possibility that we'd leave the evidence of a councillor with regard to that particular topic. So just to give you the fuller picture, I don't think that's a matter of evidence that would take very long. But in order to give you the fullest possible picture, if there is a possibility that the council under the LVI topic 1 evidence would be not only the professional landscape architect's evidence, but there is a possibility of short evidence being led in relation to the landscape and the visual impacts on Clachan and White House villages potentially by a councillor. But I
So-
haven't been in a position to take a formal view on it because I haven't seen the landscape witnesses evidence. I simply to flag that as something that might need to be factored into your timetabling, sir.
Okay, so the possibility of one of the witnesses being a councillor. So did I understand that correctly?
Possibly, yes.
Yeah. Okay.
Could I say, Mr. Smith, that I welcome what Mr. O'Carroll has just said. It is important that you hear, I think, the full resolution which the council reached when it considered this matter, where members of the council added to the concern that was otherwise expressed in the report of handling, and certainly local people here welcomed that. And I do think it's important, and I'm glad to hear what Mr. O'Carroll is saying.
Okay, thank you very much for that.
Can I concur with that, please, Mr. Smith? Because I know the councillors are extremely concerned, as are the community council, with regards to the impact on the two villages named.
Okay. Yeah, we're obviously starting to stray a little bit into the nature of the matters that might be covered, but I understand the points that you're making. Let's move on now to item 8, please, which is the draft hearing procedures for considering the socio-economic and tourism effects and for considering draft conditions. So this is the reporter's current thoughts, Annex D. So in a similar manner to what we've just done for item 7, we now consider the arrangements for hearings. As a reminder, these are less formal than an inquiry and take the form of a structured discussion led by the reporter. There is no cross-examination, so participants can present their own case and respond to the points raised by other parties. Annex D lists 2 hearing sessions, so our assumptions for timescales are also in there, and the anticipated participants, which we've already considered under item 5. Given what we've just discussed for item 7, there might be some different views on exactly the timings of these. It looks possible that we might be looking at the second week, the week commencing the 29th for these sessions. So I'll be interested to hear your views on that. And I also welcome any views on the order of the hearings, and in particular whether you think you need a full or a half day for those. So there are 2 hearing sessions, socio-economic and tourism effects and draft conditions. So let's go around and hear people's thoughts on those. So Mr. Innes first, please.
Thank you, sir. Yes, in terms of the first hearing, given the number of parties involved, that looks slightly more than half a day. Just in terms of if there's a substantive agenda, that probably looks to be over half a day's hearing. In terms of conditions, I would anticipate that's half a day. And the difficulty with that is that whilst it might have been ideal to program one for the morning and one for the afternoon, it doesn't leave much latitude. So I think it might be 2 days that we'll have to set aside. And just talking generally, the other thing might be to have a full back day for either of the other topics as well, provided for technology or other issues. So, but in terms of the hearings, I think probably it's almost easier to say we've got 2 separate days and we might be finished early, well, so be it. Rather than, I think one of the problems is that if we only set aside half a day for topic 1, it could get truncated and then people feel that they haven't properly participated. And I think just in terms of everything takes a bit longer in the virtual world, I think it would take slightly more than half a day, potentially with the number of parties. Against that background, I would set 2 days would probably be a suggestion, and if we finish early, we finish early.
Okay, thank you very much. Mr. O'Carroll?
As I indicated earlier, the impacts on the local economy were not subject of objection on the part of the council. So I don't think it would be, whilst the council could put forward a witness to deal with this topic in order to provide full as possible discussion and information to the inquiry, and we'd be happy to do so. Unless we receive an indication from you, sir, to that effect, it wouldn't in fact be the council's intention to participate in the hearing session on topic 1 on implications of the local economy. So with that said, we will potentially therefore be a shorter hearing for under topic 1, and topic 2, in my experience, typically takes half a day. But I hear what Mr. Innes has said with regard to caution, and I agree with that.
Okay, thank you. Mr. Mill?
Thank you, sir. Historic Environment Scotland will not be participating in either of the 2 hearing sessions.
Thank you. West Kintyre Community Council?
Happy with the suggestion so far. I can't see that we will be bringing up anything new or requiring any further time.
Okay. Thank you. Mr. Stewart?
Yes, I'm happy with what's said there in relation to topic 1. I will not take long.
Okay. That's fine, thank you. And we'll see if Mr. Russell has been able to join us. Okay, I don't think so. As I mentioned before, he'll have the opportunity to see the notes of the meeting. Okay, thank you all very much, and we'll move on now to. Oh, sorry, who's that?
It's Mr. Innes speaking again. Sorry,
yeah,
having heard everyone speak, perhaps was a bit too pessimistic. That sounds like the socioeconomics might well be capable of being done in a morning. And if it is actually only 3 parties, that looks like something that might be achieved. So it might be a day. I just from hearing everyone speak, that they didn't feel that the matters were likely to take a long time, but they did want to make the points. Against that background, it might be capable of being resolved in a day, rather than 2 days, if that assists in terms of timetabling. I was anticipating 5 parties, and on that basis, by the time you've gone down the table on 5 or 6 topics for 5 parties, you're probably past lunch. But
yes, I think there's a balance of risk for me to I think considering this. But no, I appreciate your return on that matter. Okay,
I was wrong.
Thank you all very much. Right, let's move on then to item 9. Item 9 is the provisional timeline for submissions. The reporter's current thoughts to be finalised in the note of the meeting, and Annex E was attached. So far in our meeting today, we've considered topics, we've considered procedures, and we've started thinking about their timings. Item 9 and Annex E brings all of that together into a proposed timetable for submission. However, the first thing I need to say is that the timetable set out in Annex E will need to be revised in light of our discussions today. Firstly, to take into account what we've discussed about the landscape and visual impact assessment. We were discussing, if you recall, at the start, the likely date of publication of printed copies being a little later, and we thought we could fit that in. So that is likely to move. And also, as I mentioned in the previous items, the inquiry timing is likely to be 2 weeks later, and therefore a number of the submission points that are reliant on that would also therefore need to move in line with that. So it will need some revision. What I'm going to do is go through each of the submission points. I'll talk about the likely dates of submission and the timescales involved, and then I'll come round each of the parties at each point, and that way we don't get confused with too many things at the end. So the first thing is confirmation of participation. So all parties need to confirm that they will participate in the inquiry and hearing sessions identified by the note of this meeting when it comes out. I realise that people have already made expressions of interest in participating during this session, but we need to give you a chance to properly consider that once you've seen the note of this meeting and you can see everything laid out. So please do that within 14 days of that note being published. You will be sent copies directly, and it will also be published on the DPO website, and I hope very much to publish it on or close to Monday the 28th of June, which is within 7 days of today's meeting. If anybody isn't clear on this, can you please indicate now? Otherwise, I think I'll just assume that everyone understands and agrees. Does anybody want to?
Sorry, sir.
Yes, please.
Are the 14 days from the 28th of June immutable? I shall be taking my first holiday in 18 months for a fortnight.
I certainly can't blame you for that. Certainly, I would be I'd be kind of happy to allow some leeway. I'm just trying to think of some timescales. I'll come back with some timescales, but I'm certainly happy to give you the chance to respond on that. I suspect given what you said already today, we already know the answer, but it is a formal opportunity for you to do that. Any other points before we move on? Okay. The updated landscape and visual impact assessment work we have already discussed earlier on. It was agreed that the 26th of July was like the date when it would be submitted. 28 days to comment would give people till the 23rd of August. I think we've already discussed the details of those, so unless anybody's got anything for me, I'll assume everybody understands and agrees. Okay. Next, further written submissions. Matters upon which further written submissions are sought will be set out in the note of this meeting. Those parties asked to submit them should do so to DPA within approximately 6 weeks of this meeting. And at the same time, what you would need to do is circulate those to other parties who've opted into the process as well, and parties would have 14 days to comment if they wish. And the comments that anybody makes will need to be circulated to DPA, of course, but also to the other parties as well. We have already discussed those items, the further written information, further written submissions under items 5 and 6. So unless anybody has got anything, I'll assume that everyone understands and agrees on those points.
Yeah, following us above the applicant, I was just going to come back on 2 points.
Yes.
The first is in terms of the RSPB position,
yes.
The information that was sent to them is the same as the additional information submitted to SNH, which was part of the additional information.
Okay.
So I mean, it's not for now, but it was just in formulating whatever you might.
Right. Okay. I suspect we will formally need to ask you for it, but yeah, I understand what you're saying to me. Okay.
So that it was it's already been published as additional information, that material. The second point was in terms of the written submissions, we would suggest that the planning update be lodged at the same time as effectively the deadline where the hearing and inquiry statements and the agreement of statements of agreed matters are submitted, and that would afford that document really being we'd potentially have an agreement on planning matters, but also it would be sensible to at least have seen what other material and post the cumulative material that have been submitted and considered to ensure that whatever position statement update was provided was had full regard to those materials. So perfectly happy with all the other written submissions for the 2nd of August, but suggest that the planning and policy update should be at the same time as statements of agreed matters, as it sort of sits within that context, and we will be seeking to agree as much of it as possible. And that's something which we've already commenced. And it would also be able to take into account any matters that arose from the cumulative material, which, if it was on the 2nd of August, would have allowed a very limited opportunity to be considered.
Yeah, sorry. So, so to understand you correctly, yes, you're saying, given the later date of the availability of the visualizations and those other bits of material and people's ability to comment on them, then that's something you would expect to feed into that material. Hence,
yes,
you think it might be better. Yeah, I can see that. See whether anybody's got any views on that. Anybody want to come back on that at all? No, people are comfortable. Okay, thank you very much. We'll clarify timescales for those things in our note. I'll move on then. So inquiry statements. So for those taking part in the assessment of landscape visual cumulative effects or the effects on the setting of Dunscape inquiry sessions, then statements should be submitted 10 weeks in advance of the inquiry. So that will be on or around the 13th or 14th of September. I'm saying both those dates at the moment because I'm yet to decide whether it will begin on a Monday or a Tuesday, and part of that will depend on my consideration of what we discussed a few minutes ago. The inquiry statement should outline the case to be argued, list the documents that will be relied upon, and the witnesses who will speak at the inquiry, including topics that each witness will cover. It will also be helpful to know who will be leading the case and cross-examination of witnesses. We have touched on these matters earlier in the agenda, but I will just check now whether anybody's got any comments. Mr. Innes?
I think, no, that certainly makes sense. And there was a certain sense in the document pairings, the statement of agreed matters going in on that same day as well. It's sort of that whole point of we've crystallized the case. So there was a logic to the previous deadline, which had been on the 30th of August, including those matters, in the sense of they are all interconnected to a degree. And I think that did make sense. So no, perfectly understandable, and I agree.
Okay, thank you. Mr. O'Carroll?
Nothing to add, thank you, sir.
Mr. Mill?
No, content with that as well, sir.
Thank you. West Kintyre Community Council?
Content with everything said.
Thank you. Mr. Stewart?
Nothing to add, thank you.
Thank you. We'll check whether Mr. Russell has joined us. No, okay. Thank you all. Right, we'll move on to then precognitions. So each person presenting evidence in the inquiry sessions is required to submit a precognition 2 weeks in advance of the inquiry. So that will be on or around the 8th or 9th of November, again, depending whether it starts on Monday or Tuesday. Precognitions are detailed written statements of evidence to be presented at the inquiry. They should nonetheless be concise and provide a clear summary of evidence of the witnesses. They should be no more than 2,000 words long. In the interest of efficiency, each precognition should be drafted so as to allow it to be incorporated directly into the inquiry report as a summary of the party's case. Any evidence to the contrary or points conceded in cross-examination or in closing submissions will be addressed by the reporters in our conclusions in our report to Scottish ministers. I've touched on precognitions earlier, but I'll just go around and check that everyone's happy with this. Mr. Innes?
With that, the only deadline that I felt was quite tight was one week between the hearing and inquiry statements and the lodging of documents. I would have thought that should perhaps be 2 weeks, because it then allows parties to consider what's in those documents and potentially adjust and amend. So that, in terms of that particular process, that would also tie in that if the planning submission was made on that date, there would be a 2-week period, and that would match that as well, that the responses to anything in the planning submission would also have to be dealt with on the same day that the documents were lodged.
So you're asking for a 2-week gap between the submission of statements and the submission of documents?
Yes.
Okay. Could we pick that up when we get to document submission? I've got that in mind, so I can. If you'd like to come back in and make the same point when we get to that, just to avoid confusion. But you're content with the precognition?
Indeed, thank you, sir.
Okay, Mr. O'Carroll, accepting that we'll talk about the document submission point that Mr. Innes has raised when we get to that in a few moments.
Nothing to add, thank you.
Okay, Mr. Mill.
Nothing to add. I was just going to raise the document submission date, but referring to that.
Well, that's fine. We'll pick that up in a few moments' time then. West Kintyre Community Council.
Nothing to add.
Mr. Stewart.
Nothing to add.
Okay, Mr. Russell, if he's there. Okay. So next, hearing statements then. So hearing statements should be submitted by 10 weeks in advance of the inquiry beginning. So that will be on or around the 13th or 14th of September. Statements should provide full details of the case put forward, list the documents that will be referred to, and any specific witnesses taking part. So I'll just go around and check views on that, Mr. Innes.
Thank you, sir.
Okay, Mr. O'Carroll.
That's fine, thank you.
Mr. Mill. I suppose it doesn't affect you because you won't be participating.
Correct. Thank you.
West Kintyre Community Council.
That's fine.
Okay, Mr. Stewart.
Fine.
Okay, and Mr. Russell. No. Okay. Okay, document lists. So I'm going to do document lists first, and then I'll come on to document submissions in a moment, so we can pick up those points there that we've just discussed. Hearing inquiry statements must include a list that identifies any document that parties intend to reference in their evidence. And please, when you're doing that, can you provide the paragraph or drawing or figure numbers for ease of referencing, so people know exactly which part of the document you're talking about. Can I ask that the applicant takes the lead on assembling a core document list? Now, Annex E dealt with initial dates by which document lists should be completed, but not the early stages of preparing those things. So I would propose that an initial core document list be produced and circulated to participants. Comments, I'm going to suggest 6 weeks from the date of this meeting. That would coincide with the date for circulating further written submissions, and it would seem sensible for parties then to have 14 days to advise of any documents which they think might be missing from that list, including some which they may wish to refer to, but which are not otherwise on it. I would then ask that the finalised version of that list is submitted to all parties 12 weeks prior to the start of the inquiry, and doing that would give parties 2 weeks, therefore, to consider the list and to use it to reference any documents they wish to identify in their inquiry or hearing statements, and that way the vast majority of document references would be using the same convention and the same system. I would be prepared to accept an updated list no later than, now I've said initially 9 weeks prior to the start of the inquiry. That was designed to coincide with submission, accepting that we'll be having a discussion on submission shortly, so you might want to pick that up as we go through our discussion shortly. That update could pick up any documents identified in lists for inquiry and hearing statements that were not previously identified on the finalised core document list. I should also mention that we now have some experience from these, from various cases, and I intend to identify a general structure that's been noted by other reporters to be helpful. That's not an onerous thing, it's just an indication that I'll put in the notes of the meeting about how we found it helpful to present that. To be clear, therefore, I'm asking the applicant to lead on a single core document list, and I'm asking for that to be available in time for participants to use it and its referencing system for the lists of documents that they might wish to refer to in their hearing or inquiry statements. I will come to submission of documents next, as I've mentioned, but I just think it's easier to deal with the list first and then the submission separately. So let's just go around. Mr. Innes, please. I've obviously asked something of you, so do you want to just explain whether you're content with that and any other observations you've got?
No, absolutely, Sarah. Again, it's part of trying to make this whole process more effective and efficient, and we'll certainly do whatever we can to assist with that, and are happy with the timescales that have been put forward. But we will seek to liaise with other parties to make sure that the document lists are effective, because that's how it works really well. So we'll make sure that we liaise with other parties and ensure that that document list is as full as possible and also is structured in the way that you want. And we agree structure greatly helps in the electronic inquiry, because often you then just need that section open and you can access documents relatively easily. So it does make a difference in these virtual times, and we'll do whatever we can to make it as straightforward as possible.
Thank you very much. Mr. O'Carroll?
Yes, very pleased to hear that. I think it does assist the inquiry hugely if there's just a single document list that it's working from. Whereas in the past, under traditional inquiries, you'd be having a core list and then a list for the other parties separately, in which you'd end up dealing with 3. So with a single list of all documents, I think that'd be very helpful.
Sorry, Mr. O'Carroll, I think Mr. Smith has lost his sound again. He's just going to swap his headphones over. Bear with us.
Okay, can you hear me?
I can hear you. I was simply commending what had been said, and I think a single document list is by far the best way to go ahead. Thank you.
Right, that's fine. Thank you very much. And Mr. Milne?
Yeah, I agreed with everything that's said, sir, and I've got nothing to add.
Thank you very much. West Kintyre Community Council?
Agreed with everything said, nothing to add. Thank you.
Thank you very much. Mr. Stewart?
Agreed.
Thank you. And we'll check if Mr. Russell has joined us. No. Okay. So we'll now move on to document submission.
Just one matter
sorry,
that
Mr.
arises.
Innes.
Yeah, there's one matter that arises from the whole cooperation over documents, and that is if parties want to be communicated with, they have to give the DPA their email addresses and have agreed that they can be given to us so we can start that communication.
Yeah.
So if we want to that process for being kept in the loop and participating, we have to be able to communicate with all the parties, but that needs their cooperation too, because so that's just one matter which as again it's very important that everyone is involved and that everyone gets these lists to make sure that they see what documents are and there isn't duplicates or worried about documents that have or have not been submitted, but that does require us to communicate with everybody.
Yes, thank you for raising that. Yeah,
Okay.
absolutely. No, that's that was understood, and it is something that I will be coming on to. So when we get to that stage, it'll be just a short while along the agenda. So we can pick that up as well. But no, I'm pleased you've mentioned it. Okay, let's move on into document submissions. So all parties need to receive copies of all of the documents that will be referred to so that everyone can see everything. However, we also want to avoid duplication, as we've just been discussing, and email boxes being filled up with multiple copies of the same document. The aim of using the core document list is so that all core documents can be provided to all parties in one go. And this would happen by having the applicant submit to DPA in electronic format the entire core document suite. This would then be uploaded to the DPA website. It would need to be titled so as to have the core document references first, and I'll cover all this in the note of the meeting, but that can often help with just ordering documents and then finding what you're looking for. This would need to happen as part of the document circulation. Now, we'll talk about the timing. My initial assumption had been 9 weeks before the start of the inquiry, so that would have been 1 week after the submission of hearing and inquiry statements. Noting what Mr. Innes said a few moments ago about asking for a 2-week gap between those, we'll discuss that shortly when we go round. Any documents listed by your hearing or inquiry statements that are not on the core document list would need to be circulated by you to all the other parties, because if you don't do that, then they won't have them. Separately, I need to advise you that DPA has been undertaking work in collaboration with external stakeholders to create a core document library that will hold documents most commonly submitted to DPA by participants in renewable energy cases. And I need to just read you a note about this. The aim is to hold frequently referred to documents in a central place, which participants can then refer to when making their submissions to DPA. This will allow participants to provide a hyperlink to the document's location in the core document library rather than submitting a separate PDF version of the document. A similar library already exists for planning environmental appeals on that section of the gov.scot website. What we're asking, therefore, is when you're writing hearing or inquiry statements, please do not hyperlink to documents that are on your website or on other websites. If you're hyperlinking, please only do it to the DPA core library, because website addresses can often change, and that can be quite problematic if we're trying to find documents. Now, work to create that library is ongoing, and it's hoped that it will be active during the summer of 2021. Case officers would contact participants in renewable energy cases with further guidance on how the library will work once it is live, and confirmation of the documents contained within it would be circulated once finalised. However, having just said that, I can't give you a date yet when it will become operational. So for now, we need to proceed as if the status quo exists until such time as we're told that the DPA core library is operational. Now, it would be optimal if all of the documents referenced by inquiry and hearing statements were already part of the core document list drawn up by the applicant. Any documents not on the core document list and not in the DPA core library would need to be submitted to all of the participants by a week by the relevant time when that we'll discuss shortly. So I'm just reiterating that point from earlier. So separately, documents for the inquiry and hearing sessions themselves, I would also like to ask the applicant to copy the entire core document suite, all hearing and inquiry statements and precognitions, including any submitted documents not on the core document list, onto USB sticks. And these would then be circulated to all participants 2 weeks in advance of the inquiry beginning. This would give all participants the ability to quickly find documents relating to the inquiry from a consistent set of information, and it would also avoid people having to try and open large documents over the internet when they're already trying to stream the event at the same time. So I've said quite a lot there, so I'll just recap. I've said 5 things. I would ask if the applicant could lead on submitting all core documents. At the moment, we're talking about 9 weeks, but we'll discuss that 9 weeks in advance of the inquiry, so that these can all be uploaded to the DPA website, ready for people to view in the run-up to the inquiry itself. Any documents you list on your inquiry or hearing statements that are not on the core list needs to be circulated by you to all the other participants, including the DPA, and that should be done at the moment 9 weeks, but we'll discuss whether that's going to be 8 weeks before the inquiry. It may be necessary for an updated core documents list to be provided, and this could be done at the point of submission. The DPA core library is hoped to be operational in the summer, and you will be advised as and when that happens. And I am also asking if the applicant will be willing to transfer the entire core document library and other submitted documents that I've mentioned onto USB sticks and to circulate those to participants in advance of the inquiry. I need to make clear now to you as well that late document submissions will not be accepted without a compelling reason, and I stress the compelling part of that. So let's go around and check everyone understands or agrees or is happy with that and deal with any issues. So Mr. Innes first, please.
Yes, sir, thank you. Applicants more than happy to put everything on memory sticks and to circulate at the appropriate time. Happy with the approach regarding core documents. Happy to proceed on the basis of we may or may not have the hyperlinks, but if it does, we would be keen to work with the system, because it's key that if that is set up, that we get it up and running and use it. So we'd be delighted if it is. If not, we'll revert back to the PDFs, etc. So absolutely, and yes, I think we want an extra week to compile it all to get it ready for we'd probably say 8 weeks before rather than the 9. But apart from that, we're agreeable to everything you suggested, sir. Thank you.
Okay, thank you very much for that, and thank you for agreeing to do those things. So I'll ask everybody else now to come in as I go through everyone else, and can you please give me your views? And Mr. Innes has suggested the submission of documents 8 weeks prior to the inquiry instead of 9. So I'd be interested in any views you have on that. So Mr. O'Carroll.
I have no objection to the documents being 8 weeks prior to the inquiry, and in fact, I go further than that and say that the 2-week gap between the inquiry statement and the documents makes sense for the reasons given by Mr. Innes. And as for the rest, I'm totally in agreement with that. Could I just ask one clarification? You said that USB sticks would be provided to the participants. What was the time in advance of the inquiry? Yes. Did you state, sir?
We were asking for 2 weeks in advance of the inquiry, so that was just the documentation would have been available to everybody anyway. It's just so that when you turn up at the inquiry, you have all the material to hand.
I was going to ask that anyway, but that's very helpful. Thank you.
Okay, Mr. Milne.
Thank you, sir. Yes, I'm happy with all of that, and again would support the suggestion of extending that period between inquiry statements and the lodging of documents, in particular because the lodging of documents will include the lodging of inquiry reports as discussed by Mr. Innes earlier. Those reports can take some time to prepare and need to be prepared with reference to what's disclosed in the inquiry statements.
Okay, thank you for that. West Kintyre Community Council, please.
Yes, happy with everything we said. Mr. Innes will, of course, need to know all our private addresses for sending USB sticks to.
That is correct. Yes, and I'm glad you've also mentioned that again, and I was going to come to that shortly in the agenda. So if everyone's okay, if we can discuss that particular bit when we get to that point. then that will be welcome. Mr. Stewart?
Content, thank you.
And we'll see if Mr. Russell's been able to join us. No, okay. Next then, conditions. A set of draft conditions should be agreed by the applicant and the council, and we've already had indicated to us that that process has been initiated. So we've talked about, I believe you mentioned that you'd shared those already. We were certainly looking for a first draft with initial responses for each party to be lodged at the same time as further written submissions. So that's 6 weeks after this meeting. So we can comment in a moment on the timescales. Parties would then have 14 days to comment on that if they wished, with a second draft being the draft to be submitted 10 weeks prior to the start of the inquiry. And that would need to take the form of a written statement identifying areas of disagreement and alternative approaches where possible. So let's see what people think of that then. So Mr. Innes, please.
I'm very happy with what's proposed, sir. Thank you.
Okay, thank you. Mr. O'Carroll?
Nothing to add, sir. Thank you.
Okay, Mr. Milne?
Nothing to add.
Thank you. West Kintyre Community Council?
Nothing to add, not part of conditions usually.
Okay, thank you very much. Mr. Stewart?
I'm sorry to ask a question again.
That's okay.
From lack of experience. If the conditions are being, as you say, agreed between the applicant and the council, or areas where they can't be agreed are being sent out, if another party, whoever that might be, finds themselves in disagreement with one or other condition that may have been agreed between the council and the applicant, for example, are you saying, did I pick you up correctly, that there is an opportunity in advance at a written stage to make that known to the DPA?
That is correct. Yes, yes. So the timescale that I outlined would be 6 weeks from, or around 6 weeks from today. A copy of that, a draft of that material would be available for comment. There will be then 14 days for you to comment on that. And then the parties who are preparing that would have the chance to consider their own discussions further, and indeed the views that had been submitted as part of that process, in putting forward a final document which would be submitted 10 weeks before the inquiry.
And then at the inquiry, or at the hearing topic 2, of course,
that's
mentions
right.
the applicant and Argyll and Butte. If
Yeah.
we got to the point where there was somebody else who might still be in disagreement, how do they make that known?
Well, I suppose it might be worthwhile, if you anticipate that being the case, asking to participate, and then if you decide you don't need to, then perhaps you might want to withdraw at a later stage.
I'm not asking.
Okay.
I just want to be clear.
Okay. Okay. No, that's fine. Okay, no problem. And we'll check whether Mr. Russell has been able to join us. No. Okay, so statements of agreement next. So statements of agreed matters should be prepared by the applicant along with the council, and by the applicant and Historic Environment Scotland. These should include agreement on the relevant policies applicable to the case, suggested conditions and reasoning, including the heads of terms of any legal agreement, landscape visual impact matters, and matters covered by as part of other topics identified by the reporters. This should be a jointly agreed statement of matters upon which the two parties agree. Now, I know that sounds obvious, but yes, we want you to agree. We want you to give us a statement which is jointly agreed by the various parties. Now, I think it was mentioned by those parties that I've identified that discussions had commenced already on those things, so it might well be at an advanced stage already. I'd wanted initial drafts to be exchanged certainly by 6 weeks from the date of today's meeting, but I think from what I heard earlier, that has already taken place, or is certainly in process. The finalised statement should be submitted 10 weeks before the beginning of the inquiry. I know this matter was identified under item 11, but I think we've probably largely covered that by now. So we'll go around and see what people think. So Mr. Innes first, please.
Just in terms of statement of agreed matters, we, having looked at the programme, felt that the timing of it sitting alongside the hearing and inquiry statement was sort of right, in the sense of we can't really conclude our matters on, say, LVIA until the council has had an opportunity to consider the cumulative matters. And equally on the planning matters, that's slightly dependent on other matters being examined as well, it being the latter of them. So the as set out in the programme, we'd anticipated that statements of agreed matters will be progressed, but would probably be submitted on the 30th of August. Or was
so it's like I'd anticipated. I had picked up obviously a number of timings had moved into the future. So yes, Annex E is probably not now quite correct on this. So just as the statements, the hearing statements and inquiry statements will be submitted 10 weeks before the inquiry, then so too I'm proposing that this would. I'm just trying to understand, are you disagreeing with that, or are you in agreement with that?
I'm in agreement with that.
Okay, right, that's helpful to know, thank you.
But I'm not sure about the submission of draft ones. I think they're really either concluded or not concluded.
Yes, the submission of draft was not to give me a copy of a draft. It was to make sure that there was a point at which that was shared. But you've, I think, indicated to me that that process has already initiated.
They've all been done. So in that context, we're already progressing those, and we will refine them as that material comes available over the summer to get concluded positions. And we appreciate the importance of these matters.
Thank you. Okay, Mr. O'Carroll.
Yes, as I said earlier, the statement of agreed matters is being progressed, and nothing to say beyond that.
Okay, thank you, Mr. Mill.
Yes, sorry, the same position here. We have received the first draft statement of agreed matters from the applicants, and we'll be progressing that. And I agree with what's been said regarding the timetable and the dovetailing of the various procedural steps.
Thank you very much. West Kintyre Community Council?
I don't have anything to add because we're not usually involved in the statement of agreed matters at all between the parties.
Thank you. Mr. Stewart?
Nothing to add.
Thank you. We'll see if Mr. Russell's been able to join us. No? Okay. Closing submissions then. Closing submissions are covered by item 10, but I think it makes sense to deal with them now. And we'll deal with summaries of case in just a moment. At the close of the inquiry, there will be an opportunity for closing submissions to be made. There's not a requirement to do that, but there is an opportunity if you wish. These will be in writing. The purpose of these is to summarise parties' cases in the light of the discussions at the inquiry or hearing sessions. They should not contain any new evidence. So it's only what's been part of the inquiry. Now, in light of the dates of the inquiry being later in November, ordinarily what would happen is the council and objecting parties would submit first within 14 days of the close of the inquiry, and then the applicant would have 14 further days in which to submit theirs. However, that would take us into Christmas. So what I'm proposing is that the council and other parties submit their closing statements no later than the 22nd of December. That is the Wednesday before Christmas. That would give you 2.5 weeks. And then after Christmas, I'm suggesting that the applicant would submit their closing statements by no later than the end of Friday, the 21st of January 2022. And that would give you 2.5 weeks just after New Year. So I'll just check everybody's views on this. So, Mr. Innes?
Happy Christmas. Yes, we'll be delighted to. Delighted to get done. And if we do actually get it done earlier, we'll submit earlier. I mean, it's it's just dependent on getting instructions and other matters. But if I can, we'd certainly try and conclude it as quickly as we can after we've had an opportunity to review what's been submitted. Thank you.
Okay, Mr. O'Carroll?
Yes, that would be acceptable. 2.5 weeks after for the closing submissions answered. I presume then that the summary of the closing submissions would then coincide with the date for submission of the 21st of January.
I will come to that in just a moment.
Yeah,
We'll deal with the closing.
If you come to that, then I'd be happy with that also.
All right, thank you, Mr. Mill.
Yes, that's all fine. Thank you, sir.
Okay, West Kintyre Community Council, please.
That's fine, thank you.
Okay, Mr. Stewart.
Fine, thank you.
And we'll see if Mr. Russell's been able to join us. No, okay. So I'll now move on to summaries of case. These are also covered by item 10, but I will cover it now. So we had made reference under item 10 to submitting a statement which summarises the case for the applicant and for the council and for Historic Environment Scotland. Now, for clarity, precognitions will serve as a summary of cases for all parties attending inquiry sessions for the matters that are covered by that inquiry. For other matters that are not covered by inquiries, we would ask for a statement summarising the respective party's case. Now, the agenda only mentions the applicant, the Council and Historic Environment Scotland, because their respective cases tend to be quite technical and in some instances may cover multiple matters. And so it's important to have these statements as it saves us time when drafting our report to ministers. Now, the agenda did not specifically mention other parties. However, you are welcome to submit statements summarising your case if you wish. The statements should be submitted alongside or as an annex to your closing statements. And with that in mind, I need to draw your attention to a typing error in the agenda under item 10. That refers to 28 days. It should say 14 days, or as I have now corrected it to the 22nd of December to correspond with the submission of closing statements by the council and other parties. The following sentence on the agenda under item 10 recognises that the applicant would submit their summary of case with their closing statement. That would normally be 28 days, but in this case, it's by the 21st of January 2022. Can I now ask for any views on that? So, Mr. Innes.
I just want to be clear, the summary of case in relation to inquiry sessions, you don't put anything in because it's your precognition.
That's correct.
So for all the inquiry sessions, there's no need to add anything more. The position is as set out in the precognition.
That is correct.
So it's really only all the other matters which were not canvassed in inquiry sessions that are subject to the summary.
That's correct.
That's fine. I just wanted to be clear on what was intended. Okay. So yes. Thank you.
No, that's no problem. Mr. O'Carroll? I can't hear you.
I'm content, Dan, thank you.
All right, you're content, thank you. Mr. Milne?
Content on the basis that we will not have to lodge one on behalf of Historic Environment Scotland.
No problems. West Kintyre Community Council?
Content.
Mr. Stewart?
I'm sure I'm content, but could all of that just be explained in the summary and the note of this meeting?
Yeah, all of these matters will be, so you'll be able to see them. So yes, and we'll see if Mr. Russell's been able to join us. No, okay. So then the format of submitted material. So all parties are requested to submit statements, precognitions, and written submissions in electronic format. So that will be in Word. And documents can be in Word or PDF format. A great many documents live in PDF format in any case. The exception being for any large format plans and visualizations, which will be in paper, and we've already talked about that. If anyone's not clear about that, could they just signal me now? Otherwise, I'll just assume everyone understands and agrees. Okay. Right, I'll move on to item 10. This was the procedure relating to closing statements and summaries of case. We've just discussed that. I don't have anything to add. So unless anybody else wants to raise anything on that we've already discussed. Okay, that's fine. Thank you. We'll move on to and item 11 covers the scope of agreed matters. I'm content that we've also discussed that under item 9. I don't have anything else that I would propose to add. I'm assuming nobody else does. Everyone's content. That's fine. We'll move on. So item 12, miscellaneous items. So we've brought together a number of different items here. So what I propose to do is run through each of the bullets, talk a little bit, and then ask for everyone's views. So the first of those is site inspections. So in August or September of this year, the reporters will make an unaccompanied inspection of the site and its surroundings. including some or all of the viewpoints referred to in the EIA and in representations. At the end of the proceedings, the reporters may also make an unaccompanied site inspection of the area. Parties should note that the purpose of the site inspection is to give the reporters an opportunity to familiarise themselves with the location and how it relates to the issues raised by the application. So in other words, if you see us walking around, we are polite people, so we will smile and say hello, but we can't chat with you about the case. So I assume that everyone is content and agrees and understands, unless anyone says anything different. Okay. Okay, let's move on then to exchanging documents. We've talked a little bit about this already.
Sorry, sir.
Yes, Mr. Mills.
Cut across what you're saying. In terms of the site.
Oh, I can't hear you. Can you hear Douglas Milne? We'll just wait for Mr. Milne to regain sound. It's okay. Can you hear me? We just can't hear you. All right, okay.
Hopefully that's me now.
Yes, I can hear you now. On you go.
Temporary glitch. In terms of site inspections, I think, sir, that you mentioned the possibility of 2 unaccompanied inspections. Now, I just wanted to mention that one thing that Historic Environment Scotland would be encouraging the reporters to do is to ensure that as part of your site visits, you were taking in the views towards Dunskeag from the ferry. Now that, and I don't know if you've thought that far ahead in terms of what the site visits may actually entail, but we appreciate that that may bring a number of logistical problems in terms of the frequency of the ferries, the time of the ferries, and as you get later into the year, the reducing hours of daylight. Now, we actually had discussed if there was to be an accompanied site inspection, including views from the water, that it might be possible for a private charter to be arranged in order to provide flexibility, which may also help with finding a window in the weather. Now, perhaps that's something that I can liaise with Mr. Innes about, but I wanted to raise sort of that's a discussion that we've been having with Historic Environment Scotland.
Thank you for raising that. Yes, I mean, certainly we haven't got necessarily far into the detail of our visit. Safe to say we will be looking to see various viewpoints and locations, and ferries would be part of that because that is part and parcel of what's been put to us. But for sure, I mean, if that's a matter that you want to put to us, then we'd be happy to look at what it is. At the moment, some of this is dependent on the current COVID restrictions and the amount of people that can be in one place from any number of households, and that may be a limiting factor, and we would have to explore that at the given point.
May I just come in here, Mr. Smith, but just briefly?
Yes.
I think this is a very important point because with 2 previous hearings, we have specifically taken the ferry across to Gear with the reporters on accompanied tours, obviously, because of the setting of Dunskeag and the importance of it within the area and from the seascape.
Yes, thank you. As I say, I think the factor that would limit us would be what COVID restrictions were in place at the time, how many households could be in one place. I confess that I don't know how those things apply to public transport versus outdoors versus indoors, and there would be some things to explore. Safe to say, it had been our intention to travel on the various ferries that had been identified and travel on the various routes, and to go to viewpoints and lots of other places that have been identified. So we intend carrying out a far and wide visit of the area based on the material that's been given to us.
Thank you.
Sorry, that, and from my perspective, and Mr. Pratt, that's helpful to know, because that really was the concern, to ensure that that is what was on your mind. But yes, please liaise. Please have your office liaise with us regarding any difficulties which are encountered regarding arranging going out onto the ferries, because that's certainly our understanding that there are restrictions. You may end up being restricted on where you're allowed to stand on the ferry, for example, which would be most disappointing when you're wanting to see a particular view. So if arranging a private charter is something which would just make things easier, then that's something that Historic Environment Scotland would be happy to assist with.
Thank you very much for that. Okay. We'll move on then to the exchanging of documents. Exchanging documents. So in order to allow the necessary exchanges of inquiry documents to take place between the parties that have opted into the inquiry process, you need to be happy for other parties to use your supplied email address. These would be used to circulate things like inquiry statements and precognitions, closing submissions, and some documents. I understand that all or many parties have done this by providing those to DPA already. I understand that all of the inquiry material, including inquiry documents, would be made available through the DPA website, and we've discussed that already, and the circulation arrangements under item 9. The applicant has also agreed to circulate to the respective parties a memory stick containing all documents identified on the core document list for use during the inquiry process. My suggestion would be that the applicant contacts the parties via the email addresses that they have provided, and then asks them if they are content to provide a postal address. And that way you can provide that postal address to the applicant if you wish, and then the applicant will be able to post to you the things that we've agreed to come by post, and that then is a way of making that agreement. I'll pause there, and I'll just ask now if that's something people are comfortable with as a procedure. Okay, nobody's saying no. Thank you. I also need to make clear that the Coronavirus Scotland Act 2020 lifts any statutory requirements to make documents physically available for public inspection if it might give rise to significant risk of transmission of the virus, or is likely to be ineffective or inappropriate due to action taken in order to control the incidence or transmission of the virus. Nonetheless, it remains necessary to place the documents on deposit for inspection by the public. The view of DPA is that it should be sufficient to give notice as to where the documents relating to the application can be viewed, albeit electronically. So I would like to ask, therefore, if the applicant, the council, and the community council would be willing to include links on their website to the relevant part of the DPA website where these documents are kept. I'll be providing a link in the note of this meeting, so you could borrow that. Could I just check Mr. Innes first, and then the council, and then?
Yes, yes, sir, that would be absolutely fine. I just had one matter to say that we have actually recently been involved in site inspections utilising the ferry, and we were allowed on deck. So we've had fairly recent experience of it. So, and again, what we would endorse is that using the better weather and the opportunities for better visibility, it would be far better to go and look at it over the summer and trying to do things in the short winter days when really it's not very efficient, and also lighting is not particularly good. So we actively encourage the unaccompanied basis in which you propose to do and go and see as much of the material at this stage and at this time of year, as opposed to having heard evidence or whatever. We fully endorse that and encourage a full site inspection at this stage. And as far as the other matters are concerned, we are more than content with that link and happy to facilitate and work with all the other parties about sending documents out and engaging with them on those matters. And we've done so on other inquiries, and it's worked very well, and it ensures that we get the documents and the material to people as quickly as we can.
Thank you. Mr. O'Carroll?
No difficulty with that, whatever.
Thank you very much. And West Kintyre Community Council?
Yes, that's absolutely fine. Thank you.
Thank you. And before I move on, I'll just check whether anyone has any further observations on these points. I've obviously asked those three parties to comment. Is everybody else content? Okay, DPA contacts. So all contact with DPA should be through Karen Cowie, who is the case officer for the application. I think a number of you have already been in touch with Karen already, or she has been in touch with you. But I will provide details of her contact address and details in the note of this meeting. Please note that due to leave arrangements over the summer, it may be that if you send in queries by email, they get responded to by a different case officer. Please don't worry about that. Just please behave as normal, reply to that one, and because they'll be handling things on Karen's behalf and it'll be managed at this end. So that's just to advise you of that. Any comments or queries at this point? Okay. Webcasting. Okay, I need to read you some remarks, very similar to what I read at the start. The virtual inquiry and hearing sessions will be broadcast live on the internet for the public to follow. They will also be recorded, stored as part of the DPA's webcast archive, and will be capable of repeated viewing. By participating in those virtual sessions, you are consenting to being filmed and to the use and storage of those images and sound recordings and any information pertaining to you contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. Further details can be found on the DPA privacy policy, which is on the DPA section of the gov.scot website. And as I mentioned before, I will add a link to that particular part of the website into the note of the meeting so that you can inspect that if you'd like to. Does anybody have any comments or queries? Otherwise, I'll assume everyone's happy and agrees. Okay. A note of the meeting. I've already talked about that quite a lot already. A copy of the note of this meeting will be circulated to all of those parties who have opted in, who are present today, and also to those who are not present. So Mr. Russell, if he's not been able to join us, will receive a copy. It will also be published on the DPA website. I hope very much to issue this within 7 working days of today's meeting. That note will formalise all of the matters discussed today, including timetables and requests for various submissions. That note should therefore be treated as a procedure notice with regard to those matters, and for the avoidance of doubt, we don't intend to issue a separate procedure notice on those matters. On receipt of the note, parties would then have 14 days to confirm whether they wish to take part in the inquiry hearing sessions, and it's important that you respond within the specified time period to guarantee participation. And Mr. Stewart, you'd asked for a little bit longer, so we'll advise you of that in the note. Perhaps 7 days after that, if that's acceptable. Yeah. Arrangements for the inquiry will also be advertised in the local press in due course. Does anybody have any comments? No? Okay, that moves us on to item 13, any other business. I asked parties to submit in advance any matters of additional business not covered by the agenda. I haven't been advised of any, and I think we discussed Mr. O'Carroll's issue earlier. So I'm assuming that there are no other matters of any other business.
Yeah, sir, if you don't mind, there's just one matter that couldn't have been notified in advance, just by way of information, that you'd be aware of the fact that part of the objection by the council related to air traffic. And I've just received the latest confirmation from NATS, being the body involved with that, that it would appear that mitigation is possible, so that is a matter that probably will just fall away in due course, but as yet hasn't been finally clarified. But I just wanted to notify you that that is something that will be very, very likely something that will fall away.
Thank you, that's helpful. And I note obviously that as we discussed earlier, that is one of the matters that we will be covering with further written submissions. So
that's right.
Opportunity to have the procedure for that.
And if that is the position, obviously, that we won't be providing any further written submissions in that regard, because it will be that by that stage unnecessary.
Although presumably you might clarify in response that if it's your position, or the council's position rather, that it's content with what it's receiving, it therefore draws its objection or takes a different view, then it perhaps would express that to us.
Yes, absolutely, sir.
Right.
And just one other matter as well I'd like to raise. That was by way of information, and then have now by way of question. And I want to ask the blindingly obvious, but there'll be a reason for it, that it'll be clear why I'm asking this in a moment.
Okay.
And one thing that's been mentioned is all of the various dates in advance of the inquiry as to 10 weeks before for the statements and so on, and 2 weeks prior. What hasn't actually been set down in absolutely explicit terms today is the date of the start of the inquiry. Now, you mentioned that it would be one of two possible days. And can we just proceed on the basis of, for the sake of discussion, that because you mentioned recognitions would be due on the 8th or 9th of November, and they're required 2 weeks in advance, that we're talking the 22nd or the 23rd of November start.
Mm-hmm.
Now,
yes, that's certainly what we're looking at. And obviously this morning I wanted to explore the people's views of that. Yeah, sorry, continue.
okay, well, I don't think we've fully explored all of that in total at the moment. And I say that for the following reason, that for understandable reasons, you have to proceed today on the basis that things will be on the 22nd or thereabouts of November as they are today, and that is that everything is to be done virtually as we're doing now. Matters might well change between now and November in terms of government guidance and the restrictions that would be operating under. So if, for example, there were to be a change and we were to proceed to an in-person hearing, the date of the 22nd of November is something that I would like to raise now, because in that event, the way in which the inquiry would have to proceed would have to be one of two ways, and that would have to be locally in Kintyre, or would have to be virtual with regard to the availability of one of my witnesses. My planning witness, for family reasons, will have difficulty in being available on the week of the 22nd of November if it were to be held in a main centre such as Glasgow, because that would then require overnight stay, and that would be not possible for her to comply with, and she is obviously essential to be there. If, on the other hand, things were to change and there were to be an in-person inquiry, but it were to be held, for example, in the Inverary Inn or in Stonefield Castle, both of which I suggest might be appropriate venues, then therefore there wouldn't be a problem. So I wanted to raise that now because the 22nd of November wouldn't be a problem in those two scenarios. Either it was wholly virtual, as we're anticipating now, or it were to be entirely local in one or other of the venues that I just mentioned.
Okay, thank you for advising me of that. Yeah, that reflects the points I think I'd picked up in the council's position statement in any event. Certainly, I am not in a position to promise in-person hearings, and I've made clear throughout this that certainly isn't what we're working on the basis of. At the moment, our assumption is that it will be virtual, and that remains the case. Nothing has yet changed. DPA policy remains the same, and I simply cannot promise anything different to that. And I don't intend to do so just now. But it's helpful to have those things in terms of assisting us in planning the exact dates, which we'll make clear in the note of the meeting.
May I come in, Mr. Smith?
Yes.
I fully agree with what Mr. O'Carroll is saying, and one of our comments was going to be the community themselves, if possible, and we do accept the COVID restrictions. We cannot at this moment in time say yes or no, but the hearing is held in person, face to face, so that the local communities most affected will at least have the opportunity to, those that may wish to attend if they so wish, part of the hearing and see how it goes on. We have a suggestion that there is a very large modern, with all facilities, village hall actually in Whitehouse that has been used many a time by SPR, the applicant themselves, for holding large community meetings. And if COVID regulations allow, we see no reason why it couldn't be held in Whitehouse Village Hall, which has a large meeting room, a small meeting room, full modern facilities, a huge car park, and is right on the site virtually that we're talking about.
That's helpful for you to identify those things for us. If it is the case that circumstances change significantly, then it is likely that we would convene a second pre-examination meeting to consider those matters in more detail. However, for the moment, and for understandable reasons that we're all aware of, I'm not in a position to do that any further. And of course, it's helpful that you've identified those locations. If it was possible, then those might be ones that we would look at. Of course, it would be dependent on their availability and their ability to comply with whatever restrictions are in place at that time. But a future pre-examination meeting would be capable of taking views based on whatever the situation would be at that time, which is very difficult for us to predict today for very limited reasons.
May I just further add, if I may be so bold, that if it was to be a face-to-face anywhere but locally, I'm afraid as volunteer, I would be totally unable to attend hearings because I will not fund myself in hotels in Glasgow or Edinburgh or anywhere else.
That's understood. That's understood. No, I appreciate that, and thank you for advising me of it. Okay, I've taken on board those matters. Before I close the meeting, then, are there any other matters? I think I'm just considering the start date because I think Mr. O'Carroll mentioned that. I think I need to look in detail at what everybody has told me about programming of inquiry and hearing sessions and work out whether it would be the Monday or the Tuesday, but we are looking at either the 22nd or the 23rd of November at the present time. And I simply need your patience to allow me to work out some of the logistics of that, given the various availabilities that have also been talked about as well. So I will do that, and that will be in the note, and it will be made clear at that point. Okay. In a moment, I'll conclude the meeting if no one's got any other business that they wish to raise. Going once, twice, 3 times. I now formally close this meeting then. Thank you all very much for your constructive participation today. I look forward to seeing you all in November, and until then, best wishes and good afternoon.
Thank you.
Thank you very much.
Thank you.